ndandina-20 years ngosumitha kwam and umama wakhathazeka kakhulu ngokukhulelwa kwam ndiphinde ndikhanyelwe. Wakhathazeka kakhulu kangangoba umama waba nento endigxothayo xa ndimdisappointa ndimithi ndimncinci. Lo mfana yena wandimithisa ndamxelela ukuba ndikhulelwe. Wathi yena singuye, ndinobuntu, velani, ndihlala apha ePruto. Impilo yami yokuqala yayisezinkosini. Ngoku ndofika apha ePruto khange ndibone into yankosi. Ndazifila mandi bakumandi apha kum. Into zalapha ePruto sizisaphi emagistrate. Noba umntu sebile noba sebulele ibheka phi emagistrate engqushwa. Tatomkhulu wam wathi maliye kaSibonda elityala. Laya kaSibonda. Wacaba kulo mfana napha kaSibonda kule lali yabo. KwaSibonda naphaya uyaliqhasha elityala. Mina anamthetheleli. Kwacaba ngoku wathi utamkhulu ndiyabhena maliye komkhulu. Laya komkhulu safikela ileta esixela uba amatyala ango-August, ngo-August amatyala. Kanti kulo August ndizawubeleka ngayo mna. Ndayobeleka ngalo August ke. Yafika ileta ifika nomama ndisesibhedlele. Wacaba mandicela apha esibhedlele umntana ndimshiye. Kuyanyanzeleka uba ndibheke ematyaleni. Ndabheka phaya komkhulu. Endaweni sibizwe sobabini sibuze uba sixoxiswe sobabini sidityaniswe. Kwabizwa laa mfana. Kwabuza uba uyayazi le ntombazana? Wathi andiyazi le ntombazana. Kwacaba utatomkhulu ngoku makakhupha amanye amehlo kuba kaloku angaxoka le ntombazana ithi imitshongo kanti asiyo. Kwathiwa izawulandelwa le nto kunanamhlanje zange ilandelelwe. Since safumana saqeqeshwa laa nto amalungelo uba masiwalwe, andinawuhlasana nenkosi kakuhle mna. Ndingayixelela mna le nto ndiyifunayo. Andinawuhlasana nenkosi kakuhle. Kanti ke mna ke iinkosi andizifuni tu. Inkosi andizifuni because zange zenze into icacileyo kwazona. Amatyala babezigqibela, ugqitywe ngawo ngokukhoyo. Inkosi mna ndizifuna and so ndizifune inkosi.
South Africa is home to over 50 million people. Of these, 18 million live in rural areas where customary law is often observed. In recognition of this, the South African government has drafted a bill to empower traditional forms of justice. The Traditional Courts Bill is a piece of legislation first introduced in South Africa in 2008 to replace the archaic Black Administration Act of 1927. The bill seeks to enhance customary law and give traditional leaders the same power as magistrates' courts to rule on civil and criminal cases. The bill was rejected in 2008 on the grounds that it undermines the Constitution's one law for one nation principle. It was back under discussion at the beginning of this year, to be decided by December 2012.
I think there is a recognition and acknowledgement that in South Africa there are traditional communities. In a literal sense, that means there are people who are together practicing their own culture, speaking their own language, people who can dance together and identify one another based on the cultural values and traditional lineage of that particular tribe, community or society. As a recognition of that, Eastern Cape is predominantly a rural area. Therefore, that's why there is a lot of those traditional communities led and ruled under traditional rulership, and many people pay allegiance to those institutions.
In order to understand why the government feels that the Traditional Courts Bill is necessary, Professor Jeff Perez explains the history of traditional communities and their hierarchies.
People don't really understand how we got from the genuine old days to the present time, because traditional leaders are not that traditional anymore, especially in the Xhosa-speaking language areas. In the old days, traditional leaders or chiefs, Nkosi, did not have defined territorial areas. They ruled through the support of their councillors. So there have not been genuine traditional courts anywhere in the Eastern Cape for over 120 years. In the Ciskei, there have not been genuine traditional courts for over 150 years. As soon as the colonial government came in, the colonial government did two things. Number one, it appointed magistrates, and all so-called traditional leaders became headmen under the magistrates. Secondly, it demarcated the districts into administrative areas known as Lokshin or Lali, and the headman ruled his location.
These hierarchies are still in place. Traditional forms of justice involve various levels of dispute resolution, from chiefs right down to families.
To begin with, traditional courts deal with certain issues, but they function in a hierarchical manner. First, all disputes start at the lowest level, like the family courts, headmen's courts, and then if the parties do not reach agreement, they go to the official court of chiefs and headmen. So that we can say that sometimes they operate informally when the matter is actually settled at a level below that of the traditional court, that is by headmen and sub-headmen. Sometimes the matter will be settled at the family level.
Politics lecturer Sipokazi Magadla has personal experience of traditional justice systems and their ability to solve disputes.
In my family, we've relied on the traditional courts, customary law rather. And I remember a case where one of my brothers was involved in a fight with a young guy, and we managed as a family to solve that using traditional leaders who were able to bring together the two families. And there, I mean, we were quite happy because then what we needed to do was to pay a goat to that family. And I think we're happy to sort of not have to deal with the hassle of going to courts.
University of Cape Town's Law, Race and Gender Institute is lobbying against the bill. They also see the importance of the different layers of traditional justice systems and believe that the bill does not acknowledge this.
The bill doesn't recognize the multi-layered form of dispute resolution that applies in customary law. So what that means is that the bill only acknowledges the court of the traditional leader, as opposed to acknowledging things like headmen's courts, the fact that sometimes disputes are solved in clans and sometimes they're resolved in families.
If the bill is passed, all cases will go straight to the chief's courts. Many rural women have felt marginalized by these courts.
Ndaphathwe inkosi, mna ndiphethwe belungu. Ndiqala uva into yenkosi ngoku bendibamba. Ndingunophumzile, yona fani yam. Hlala apha ePruto. Kwaye ndaye intombi yam. Yabuyiswa emzini wayo. Ayafuna agxothwa. Isabe igxothiwe. Ifikelwa yisamani evela komkhulu. Ethi mandibuyise ezaa nkomo. Ndathi ke mina andikwazi uzibuyisa inkomo ngoba zikho kum inkomo zikumyenam. Bandibizela komkhulu bandinika isama ndaya komkhulu. Afika komkhulu ndaxoxa. Ndaxoxiswa. Ndathi ke mina ndinazo inkomo. Inkomo zikumyenam. Umuntu ebesendisa intombi yakhe umyenam ebekhona ngobisenda. Wamka ke ngokwemva kwabheka eMonti. Ndavalela. Dansabe ndiphumile kwabuza uba ndithini ndizazibuyisa nezaa nkomo. Ndathi ke mina ewe ndizazibuyisa. Kuthiwa ndizawugqithiselwa phambili. Ndathi mina ndizazibuyisa kodwa kanti ndinanto ndizawuphangelela. Ndazikhupha ndazigqiba ezo nkomo zazibizwa kum. Ndinazo ke isamani zazo naziya. Bathi ke nxa beyithetha bathi bubona intombi yam bathi iwulile. Ayikho ndithetha intombi kum. Emka kaloku yabheka ebhayi yoziphangelela. Yandishiya apha mna ndinasi ndisebenzele ezi nkomo. Utata usweleka nankwelela ngasokuhlala. Ndihlala ke ngoku mna uyabantwana bam Yaziva ndibuhlungu. Ibuhlungu kakhulu. Zange ndingene itrombo zandivale lokho laba ngumuntu. Yaziva ndibuhlungu kakhulu. Basekuhlungu namhlanje ndayicinga. Ngoba lokho akho umama ungabanje uvalele. Zangabekho umama uvalele, uvalele. Zange ndithethe nenkosi emva kokuba yandibamba zambe empile ndithethe nayo into zami ndisaba ngapha. Ndisengqushwa. Xoxe ngqushwa into zami. Xoxe nayo inkosi.
Despite many people's concerns, the Xhosa royal family places great importance on traditional communities and preserving their forms of justice.
Traditional leadership is one of the core institutional cornerstones upon which you can build that democratic structure. By being democratic, it's who we are as African people. It is only that it might seem to be different when it is looked at through the Eurocentric spectacles.
Chairperson of the Eastern Cape National House of Traditional Leaders explains the restorative element of traditional courts.
Inkundla ke zasebukhosini nezesintu zona zinkundla zoxolelwaniso ngendalo yokusekwa kwazo. Ayizo nkundla zezohlwayo zinkundla zokwenza abantu babubone ubugwenxa babo babudanele babucelela uxolo kube kuxolo phakathi kwabantu. Kuthi into yokuba abantu bakuthi kuthwe mabahambe imigama emide ukubheka kwinkundla zemantyi ngenxa yento bana abantu abathile entlalweni esiyiphilayo namhlanje bezicekisa izinto zakumawabo kuba mhlawumbe bebenethamsanqa lokufunda bona bahambe amazwe bayokuhlala ezidolophini ezinkulu bathi ngokuqabe kwezodolophu bafuna ukuthelekisa inhlalo yezodolophu nenhlalo yasezilalini.
Lack of access to magistrates' courts has prompted the need for the Traditional Courts Bill.
The law as it is not accommodating to an African way of life. And so I think perhaps this is only one project amongst a much bigger project of making the Constitution identifiable to a South African. And that means more than translating it to isiXhosa, because that doesn't mean much.
Can this bill really benefit people in rural areas if it was drafted for the people and not with the people?
Our concerns when it comes to the procedure is that there wasn't adequate consultation, and there wasn't consultation with the correct groupings of people. So our stance is that the bill did not consult ordinary rural people, who are the very people who are going to be affected by the law.
Traditional courts bill.
The LRG is concerned about the infringement of people's freedom of choice.
The bill excludes legal representation. So if a person appears before a customary court, they're not allowed to be represented by a lawyer, which is essentially very problematic given the fact that people don't have the choice to opt into these courts. So if you fall in the jurisdiction of a traditional court, you're obliged to attend that court, which means that you don't get to choose to abandon your right to legal representation.
Magistrates' courts and traditional courts work on very different principles. One is based on retributive justice and the other restorative justice. Magistrates' courts deal with law, while traditional courts often deal with custom. Traditional courts are often easier to access and cheaper for rural people. In the process of making this film, it seems many people, both rural and urban dwellers, would prefer to have their cases heard in the magistrates' court. If the bill is passed, this choice could be taken away from them.
I think
the preference we talk on the magistrate,
because it's only kuphela kwabantu abadilishana nelo.
Iikhesi zethu sifuna ziyeka amantyi. Iinkosi zona asizifuni. Zasihlukumeza ngohlobo elungumaliso. Akho nto onoxoxa nenkosi abazofuna uqala uhlawule. Mantya umhlawuli into awuxoxa ityala lakho qha aligwebe bafuna eligwebile ngenyaniso.
Abekusangam ngasindixoxa emakhayeni. Ubinto yoza apha iyadika ndikhona amayeza apha idibane namayeza imizi amayeza ngamayeza so asibe right xa silapha.
Mna iikhesi zam ndifuna ukuzixoxa ecourt ngoba andifuna ukuzixoxa apha ngenxa yento kokuba icourt yona inaso isisombululo.
Those who are against the bill have concerns that chiefs will abuse their elevated power.
The bill centralizes power in the traditional leader, which means that they are given both administrative powers, adjudicative powers, and legislative powers. They get to determine the content of customary law, and they then get to apply that customary law, which is really very, very tricky because it's actually in conflict with how things tend to work on the ground, where the court is not embodied in the traditional leader, but rather involves a very broad community participation.
It seems as if much of the animosity towards the Traditional Courts Bill comes from a history of abuse from chiefs. Residents of Prudo are particularly vocal in their arguments against being controlled by chiefs.
Ukufika kwenkosi apha ezike kuthiwa masibe phantsi kwazo ngo-1835 inkosi ibinye ibinguzukweni kodwa ngoku zi-more than 20 zivela phi ezi nkosi zingaka. One, ezi nkosi azizalwa ziyabekwa. Zibekwa ngubani? Ngurhulumente. Azibhatale inkosi. Akho nto ziyenzayo, akho nto ziyisebenzayo. Ngaphezu kwale mali ziyibhatalwa ngurhulumente basenga apha kuthi kuba sine-levies ekufuneka sizibhatele phaa.
Le ndaba yenkosi siyayinyanzeliswa. Akutshiwa kubuzwa kuthi ngoba ifika phi inkosi seyinamagunya. Ingatsho into yoba hayi kuthiwa kufanele ukuze inkosi nibe nayo nithanda ningathandi. Sifuna uqonda njengoba kwakuthiwe ngoku asakuqala u-94 kuthiwa siyavotwa kwathiwa wonke umntu unelungelo lokuthi into xa ngayifuna athi hayi. Kodwa ngoku xa sijongile apha le nto ayicengisi ku.
Sikhule lapha kwesifama sazalelwa apha. Mazihlale kulaa ndawo hleli kuyo. Mazingathi zawubona uba lo mhlaba utyebile ingathi uzawufunyanwa sizisondeze kuthi. Asizifuna uzibona. Ndiyibulisa nasendleleni. Ayihambe.
Masiqwele.
Maqwele tu. Ngolile.
Masiqwele enzinkosi. Ingathi noko siphefumlile xa sisonke. Batsho mama abantu balapha ePrudo bathi i-traditional courts bill abayifuni.
More and more poor people are making the argument that we are being treated as bodies, as people who can't think for themselves. And I think maybe this is in part this violent reaction by South Africans to say, do not think for us, think with us.
Even some who hold positions of power in rural areas believe that magistrates' courts are sometimes more effective than traditional courts.
Kweli xesha sinalo imithetho yakumkhulu ayisisebenzeli ngoku noba loo mithetho yona imile. Ngokokwam ke ndibona kubhetele into yoba ityala eli nali ligwetywe kwezaa nkundla zasekhoti kunoba ligwetywe apha ekuhlaleni. Bekunako ukuba kungaxoxwa khona ukuxoxwe. Kodwa ityala elinzima lidlulele kwinkundla zikarhulumente lingapheleli ezandleni zenkundla zasengqileni. Ibingumnqweno wam lo ngoba nam ndingumntu oke axoxe enkundleni kodwa ndifumane into yoba hayi apha kusetyenziswe amandla ebengafanelanga asetyenzisiwe. Bayabethwa abantu ngamaxesha athile ufumane into yoba lo mntu ebegqibile uyithetha inyaniso into enakufunwa enye inyani ngaphandle kwalazana.
One of the biggest concerns about the bill is the detrimental effect that it could have on women and their standing in courts. Professor Mqokeli disagrees in theory.
In the olden days, court matters were mainly matters for men. And of course, the reason was that sessions were held next to the Campbell, which is regarded as an abode of the ancestor spirits. So that women were, would avoid that place. They were excluded for that reason. When offices of tribal and regional authorities were built, there was no reason enough for the exclusion of women.
In practice, this does not seem to be the case.
Rural women tend to find themselves very marginalized by these courts, and the bill doesn't actively seek to protect them from such marginalization. So, for example, the bill says that a woman can be represented by a man, and a man can also be represented by a woman in accordance with customary law. Now, what research has found is that it's actually very rare for a woman to represent a man under customary law.
It just happened that my father was not in the rural areas and my mother was there. So she went there hoping to speak on behalf of my brother, and it was quite clear. The men said, we can't speak to you, you must bring a male figure, you must bring your husband. And so we had to wait for a case where either my father came or his brother came to speak on behalf of my brother. But of course, the bill attempts to say that women will have equal access to the bill, but there's no way to guarantee that. That's the problem.
Everyone who is actively involved in the debate about the Traditional Courts Bill has their own opinion on what should be done to improve the bill.
Our stance is actually that the bill needs to be withdrawn.
Okay.
We feel very strongly that what needs to happen is the process needs to start again with adequate consultation from the word go. Ensuring that ordinary rural people are involved from the very start, especially rural women as a separate interest group. We feel that way what will emerge is a piece of legislation that is really drawn from the people.
I don't know what the Halubalu is all about as far as I'm concerned. This bill is good. But people do not understand it. They don't read it properly. Maybe they ignore history.
I don't believe it will ever be unconstitutional, but I cannot run away from the fact that certain areas of the bill, when they are tested against the Constitution, through Constitutional Court, for instance, may have a point of being inconsistent. That I cannot rule out.
These courts must also be recognized in the same way as other courts are recognized.
Ndicinga fanele mnazi ezinkundla zethu zezona zifunekayo ngakumbi kweli xesha eMzantsi Afrika, ixesha lokuphela koxolo, ixesha lokuphela kobuntu ebantwini, ixesha lokugonyamelana kwabantu nobusela nobundlaveni. Lelona xesha eli ebezifuneka ngalo ezinkundla nokuba zixhotyiswe kakuhle zikwazi ukuphatha kakuhle umsebenzi wazo.
Perhaps what we need is perhaps a state-led, a government-led debate about why we need the bill in the first place. Forget the amendments, because they're amending it for the second, the third time now. So perhaps I think the government needs to engage South Africans at all levels on why this is a necessary move for us to make.
In the wake of deals made prior to 1994, which gave traditional leaders encouragement to support the ANC, it remains to be seen if the Traditional Courts Bill is just another ploy by the ANC to entrench their political power.